Hey guys, welcome back. Tony Denaro here. I hope you all had a great Friday and are ready for an awesome weekend. In this video, I want to go over a quick update from Judge Zurn in the Delaware Chancery Court. As we talked about the other day, the counsel for Allegheny submitted the stipulation for settlement, and we went over those details in a live stream that is available still on my channel if you want to go check that out. Today, we heard from Judge Zurn with her thoughts about that settlement before she scheduled everything. So let's talk for a minute about what are the key highlights from this letter, and then if any other updates come in the coming days, I will keep you posted. The first item that the judge mentions to counsel is that she doesn't like that they presumptively used the word non-opt-out in the scheduling order, the notice, and the stipulation. And she asked them to remove it from two of those, from the notice and the stipulation. The judge will decide at the end of June on the settlement hearing date if this is a non-opt-out class or not. And so she doesn't want them putting that in the notice or the settlement stipulation. The next couple pages from the judge have to do with how the shareholders are going to be notified about this proposed settlement. And when we talked about this the other day, when we went over the settlement, we noted that the plaintiffs and defendants' counsels, when they wrote up the settlement, even though they had just talked on the phone on Monday with the judge about how notification should happen, they still submitted the settlement with only electronic notifications through 8K, websites, emails, things like that. And it was pretty clear that the judge was telling them on Monday she wanted the shareholders to be notified by mail. And so she spends now a couple pages admonishing them about that. She goes on to say that although she is sympathetic to the cost of mailing all individual shareholders, that is the norm at the court to notify shareholders by mail. And although there have been a couple of times where electronic notification was done over the past decade, that is the exception and not the rule. She says that no good explanation was given other than the cost why they didn't want to do the mailing. And she basically said, you know, sorry, that is what you have to deal with when the majority of your shareholders are retail. You courted them, you got them into this play. Now you're going to have to bear the burden of the cost of notifying them about this settlement. She put a couple of scheduling things on here relative to the assumption that postcards will be mailed and that they do intend to still want to keep June 29th and 30th as the hearing date, that those postcards must be received by all shareholders no later than May 24th. So they'll probably need to start mailing them soon. And here we can see we have a date of May 31st, 2023. Objections must be in to the counsel for the plaintiffs by May 31st. That is your date that you got to get your objections in if you are planning on submitting an objection. The final couple things are at the bottom of the letter here. We have item number 1. She wants a couple of paragraphs deleted. Nothing really big there. There was a slightly more interesting discussion though in bullet point number 2, where she talks about in paragraph 39, lead counsel says that its claim under Delaware General Corporate Law 242B was unlikely to succeed because of a recent decision from the Delaware Court of Chancery. We talked about that the other day, that they realized that they probably weren't going to win on that because of a previous decision. She wants the plaintiff's attorneys to let shareholders know that they were the ones that lost that case, and it is currently under appeal at the Delaware Supreme Court. And so that wording needs to be added to the notice and the settlement stipulation. To wrap it up on the last page, she says, please be advised that the court intends to publish a letter to stockholders with instructions, so keep your eyes out for that. I'll let you know when that is available also, of course. And a form for stockholders to return to the register in Chancery if they have properly objected and intend to speak at the settlement hearing. And she asks that that wording be added to the notice. That is all I got for you guys on today's update. Thank you for watching. Drop me a comment if you have any questions down below. I am Tony Denaro, and I will see you on the next video.